please.
Judgment in the matter of Lipton and another against BA Cityflyer Ltd.
Lady Rose will hand down this appeal.
Mr and Mrs Lipton were booked onto a flight operated by the Cityflyer airline scheduled to depart from Milan airport at about 5 p.m. on the 30th of January 2018. They were supposed to arrive at London City Airport just after 6 p.m. local time. The flight was cancelled because the pilot reported that he was unwell shortly before the flight and it was not possible to find a replacement in time. The Liptons were rebooked onto another flight and arrived at London City Airport at about 8:45 p.m. that evening, just over 2.5 hours later than they expected. The Liptons put in a claim for compensation for €250, about £220, but Cityflyer has refused to pay. From this all too familiar tale of frustration and annoyance arise two important legal issues which made their way up through the several tiers of the court system to occupy a full day of argument before this court. One of those legal issues, raised by ground one of this appeal, is directly related to the facts of this case. The Liptons' claim for compensation was made under a European Union instrument, Regulation 261 of 2004, which I will refer to as Regulation 261. This regulation confers a right on passengers to compensation for cancelled flights, but an airline has a defence if it can show that the cancellation was the result of extraordinary circumstances. Ground one raises the question of what is meant by the term extraordinary circumstances and whether the pilot's illness, which caused the cancellation of the Milan flight, counts as an extraordinary circumstance or not. The second legal issue is potentially of much broader significance. Between the date of the cancelled flight in 2018 and the date of the hearing of the Liptons' claim before the Court of Appeal in 2021, the United Kingdom left the European Union. The second issue is what effect, if any, that had on the Liptons' ability to recover compensation now by pursuing the EU right that was conferred on them whilst the UK was still an EU member state. That issue formed ground two of the appeal before the court. The Liptons' claim was initially dismissed by a deputy district judge and a circuit judge in the county court before the Liptons made a successful appeal to the Court of Appeal, which upheld their claim. Cityflyer now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal. I will first deal with ground two, as that raises the logically prior question of what law applies to the determination of the Liptons' claim. On the date of the Liptons' flight, the UK was still a member of the European Union. At that point in time, the EU text of Regulation 261 applied in the UK by virtue of Section 2, subsection 1 of the European Communities Act 1972, which I will refer to as the ECA. By the date of the Court of Appeal hearing, the UK had left the EU and the ECA had been repealed by the European Withdrawal Act 2018, which I will refer to as the Withdrawal Act. The parties are agreed that these subsequent events could not extinguish the Liptons' accrued cause of action, but they disagree about why that is and what law applies now to the claim. The answer to these questions turns on the interpretation of the domestic legislation which implemented Brexit. I will briefly summarise the relevant provisions. The Withdrawal Act provided for certain EU enactments and rights to remain in domestic law after the 31st of December 2020. That date is known as IP Completion Day, as it marked the end of the implementation period, the IP. During that implementation period, EU law still applied in the UK, even though we had actually left the EU at the end of January 2020. The provisions of the Withdrawal Act carried forward enactments and rights. Those were referred to in that Act as retained EU law. In particular, Section 3 of the Withdrawal Act provided that EU regulations operative immediately before IP completion day remained in domestic law as retained EU law. On IP completion day, Regulation 261 was amended by a domestic statutory instrument to take account of the withdrawal of the UK from the EU. So, for example, the compensation amounts, which were expressed in euros in the EU text of the regulation, were converted into sterling after IP completion day. I will refer to the revised version as the amended regulation. By the date of the Court of Appeal hearing, the amended regulation was in force. The Court of Appeal applied the amended regulation to the Liptons' claim. The Supreme Court unanimously holds that it was wrong to do so. A basic principle of the rule of law is that the law to be applied to any case is the law in force at the time that the events giving rise to the claim occur, and not the law that applies at the date when the case happens to be heard by the judge. There is nothing to suggest that the amended regulation was intended to apply to fact patterns arising before it came into force. As regards what law does apply, there are two alternative analyses which could explain how the Liptons' cause of action was carried forward into the post-IP completion day world. First is what I will term the complete code analysis. Under this analysis, the different sections in the Withdrawal Act dealt comprehensively with the application in the UK of EU law following IP completion day. Where a cause of action arose in relation to events that took place pre-IP completion day, that cause of action is brought forward as retained EU law by the provisions of the Withdrawal Act. Alternatively, there is the Interpretation Act analysis. This analysis posits that the Withdrawal Act transposed into domestic law certain rules of EU law, but generally left undisturbed any cause of action which had already accrued under EU law arising from facts that happened prior to IP completion day. Under this analysis, such causes of action are saved not by any section of the Withdrawal Act, but instead by the application of Section 16 of the Interpretation Act 1978. That is a statute which applies generally and has nothing to do with Brexit. It provides that the repeal of any enactment, for example here the ECA, does not affect any right accrued under that enactment. A majority of the Supreme Court finds that the complete code analysis is correct. Regulation 261 was operative immediately before completion day in two ways. First, by stipulating the law to be applied to any new situations happening after IP completion day, but secondly, it also required any causes of action that had already accrued under Regulation 261 to be recognised and enforced by the domestic courts. Section 3 of the Withdrawal Act was effective to bring forward both these aspects of Regulation 261 as retained EU law. This accords with the fundamental purpose of the Withdrawal Act. That, the majority holds, was to provide a complete code for the post-Brexit legal landscape. It is implausible that such an important matter as the ongoing enforcement of pre-Brexit accrued causes of action was intended by Parliament to fall outside this new domestic regime. Looking at the matter the other way round, the majority of the Court considers that the Interpretation Act analysis would generate a number of serious problems. In particular, it creates a problem about the status in our domestic courts of decisions of the Court of Justice of the European Union in Luxembourg when a domestic court is dealing with a pre-Brexit case in the post-Brexit world. Section 6 of the Withdrawal Act makes important provision regarding the status of such court decisions post-Brexit. But the heading of Section 6 suggests that it only applies to the interpretation of retained EU law. According to the Interpretation Act analysis, this would not include where a domestic court was considering a case about an accrued cause of action. By contrast, the complete code analysis makes clear that Section 6 does apply. That means that first, courts are not bound by decisions of the CJEU which are handed down after IP completion day, and second, the Supreme Court, as well as certain other appellate courts, may decide not to follow even pre-IP completion day rulings of the court if certain conditions are met. Lord Lloyd-Jones disagrees with the majority on this issue and concludes that the Interpretation Act analysis is correct. In his view, there was no need for the Withdrawal Act to preserve accrued rights and obligations, as they were automatically preserved by operation of the Interpretation Act. We therefore address ground 1 of the appeal on the basis that the Lipton's claim is governed by the text of Regulation 261 as it stood immediately before IP completion day. Ground 1 is concerned with the meaning of the phrase extraordinary circumstances. The airline Cityflyer bears the burden of proving that the flight captain's non-attendance due to illness fell within the concept of extraordinary circumstances. The meaning of the phrase must be interpreted in light of the purpose of Regulation 261, which is to ensure a high level of protection for consumers. The basic principles regarding the application of the defence are well settled. There are many cases in the Luxembourg court dealing with different scenarios and deciding whether they are extraordinary or not. These range from cases where the flight is cancelled or delayed because of technical problems with the aircraft, or where the plane was damaged by a set of mobile boarding stairs, or because of a bird strike, or because a seriously unruly passenger on board caused the flight to be diverted. The case law shows that the principal question is whether the relevant event is inherent in the normal activity of the air carrier. The Supreme Court unanimously holds that the pilot's non-attendance due to illness was an inherent part of Cityflyer's activity as an air carrier and cannot be described as extraordinary. That phrase, extraordinary circumstances, must be given its usual meaning, which denotes something out of the ordinary. Staff illness is commonplace for any business, and pilots are no exception. It is irrelevant whether staff fall ill whilst they are off duty. Their attendance or non-attendance for work is an inherent part of the carrier's operating system. Cityflyer suggested that it was necessary before the court could decide the case for there to be a detailed investigation into why, when, and how the staff member became ill. But that would be contrary to the intended operation of the compensation scheme. The scheme is designed to provide a standard, quite small amount of compensation in a way that is easy to apply in most cases without needing to involve lawyers. The Supreme Court therefore dismisses the appeal, and the Liptons' claim for compensation for them for what happened to them on their journey home succeeds.
The court will now adjourn.
Right.